Hi, welcome to our show. For those of you who know me, you know that I get calls all day long asking for all types of advice. But of course, I'm not licensed in every industry, and I always want to refer people to the best people that I know. And let's just face it, in any industry, whether you're looking for a lawyer, a mediator, a realtor, or somebody to put hardwood flooring in your house, in any industry, there's always the top 1 or 2 or 3% of that industry. There's the whole mediocre, and then there's, well, what I call bottom feeders that you wouldn't wish on your worst enemy. So if you call me for advice or you need a referral to somebody, I'm only going to refer you to somebody that I think is in the top 1 or 2 or 3% of their business. Now, in all of my work working with hundreds of divorcing couples, I've met many of the city's top lawyers and mediators and all types of professionals. And today I'd like to welcome Howard Warren, who is a lawyer, a mediator, and an arbitrator, and quite frankly, the best I've ever worked with to date. Howard, welcome.
Good morning.
Today, I'd like to answer a question that I get asked every single week, if not every single day. To start right from the beginning of the divorce process, Howard, why don't you explain to them what's the difference between litigating versus mediating and arbitration? Or the difference between what a lawyer would do, a mediator would do, and an arbitrator would do?
Sure, I'm happy to do that. Litigation is a process whereby the couples go to court.
Okay.
It isn't voluntary. One party starts the action and then it continues on through the courts. It's a complicated process. In family law in Ontario, there are many steps that you must go through. Case conference and a settlement conference and a trial scheduling conference and a trial, and they're mandatory.
Okay.
Whereas with mediation and arbitration, it's just that, mediation, arbitration. The other thing is, with court, you don't get to choose your decision maker if you go the arbitration route. Mm-hmm. Whereas if you choose an arbitrator, that's your decision maker. He or she will make that decision. Another really important factor is confidentiality. In the court system, in both systems, you provide documentation about financial disclosure, and that sits in a court file. Okay. With mediation arbitration, it sits in my file. And why that's important is, if you've given a contact list for your business, for example, and that contact list is really important to you and your business, as it likely is, that's available for your competitors to go into court. You merely go into the filing office and you say, I want to see such and such a file, and they say, why? And you say, research. That's the magic word. They have access to that file. So confidentiality is really important.
And so with a mediator or an arbitrator, it's not public record. You can't just go into a courthouse and look up files.
Absolutely. It's in my office. It's confidential.
Okay. And so if we might just back up a minute, you and I have talked at great length about the advantages of mediation over, let's say, any other option. Can you just tell everybody in simple and direct terms, what is mediation?
Mediation is a voluntary process whereby two people agree that they will retain the services of a mediator to try and help them resolve the problem. Again, I stress it's voluntary. Unlike litigation, where one party starts the action and the other party is necessarily dragged into it.
So people don't have to go out and hire their own mediator, whereas if they were getting a lawyer or litigating, they would. With a mediator, you agree on one mediator to help you both reach an agreement.
Yes, and there are different processes. You can have mediation, or you can have mediation arbitration, which means mediation arbitration is at the end of the mediation, if it fails, if you don't succeed in reaching an agreement, the mediator then becomes the arbitrator.
Okay. And well, what are the advantages of mediation?
Well, mediation is it's less confrontational.
Okay.
It tends to be quicker. Mm-hmm. And because it's quicker, it's less costly. Okay. And you've chosen who your person's going to be to facilitate your resolution.
Okay. So if I were to get divorced and I want things to go quicker, smoother, and less costly, you've got me sold already on a mediator, but is everybody a candidate? If I want to go the mediation route, does my spouse or my soon-to-be ex have to be in agreement, or what do I do?
Very good question. First of all, a mediator can't resolve a divorce, so the divorce itself can only be granted by a judge. Okay. But all of the other issues, which we call the corollary issues, can be resolved by way of mediation. It's really important that you agree on the mediator because, as I say, it's a voluntary process. So if you don't agree, you're going the litigation route. Okay. So it's imperative that you agree on the mediator, and then participate with a view to coming to a resolution. The candidates who are inappropriate for mediation would be those where there's a power imbalance, where one party exerts much more power in the relationship than the other. To take an extreme view, if one party were to say to the other, we can talk about custody at mediation or arbitration, but if you get custody of the kids and take them away from me, I'll kill you. It's not really an appropriate case for mediation arbitration. And so it's imperative that there be screening before mediation arbitration to determine whether there's power imbalance.
Okay. And so if I wanted to go the mediation route, like I just said, I would have to approach my soon-to-be ex, and she or he would have to agree both to go to the mediation route, and then we'd have to agree on a mediator.
Absolutely.
And what happens, I'm sure this is common, what happens if one partner, soon-to-be ex, doesn't want to? What would you suggest to someone like me if I wanted to go the mediation route, or to anybody who wants to go the mediation
Well, again, it's a voluntary process, but the way you could persuade them would be that it's, again, much less confrontational, it's less costly, it's faster, and you know who your person who's going to facilitate the resolution is going to be.
Okay, wonderful. And that sparks a memory for me. I've been doing this for many years, as you know, and long before I had the pleasure of meeting you, I had met a mediator, and he was the first person to educate me on what a mediator is and what a mediator does. And one of the things he told me, he's not a lawyer or an arbitrator or have the credentials that you have. And I remember when I spoke to him, this is going back years ago, I asked him, what's the biggest obstacle for him as a mediator? And he not only shared that with me, but enlightened me as the process. He said, well, after I mediate and I help a couple reach an understanding, reach an agreement on finances, custody, etc., he said he still can't draft a separation agreement. It still has to be referred to a lawyer to do that. And I'm sure we've all heard the term, you have to get independent legal advice or independent legal counsel. Now, of course, that doesn't apply to you, because as a lawyer, you can do that. But do you ever have any experience where a mediator or yourself will help a couple that's willing to mediate reach an agreement, and then for any number of reasons, when they go seek a lawyer, complications arise after you think you've reached that agreement?
That can happen in mediation, it can happen in litigation, it can happen in any process. When you have two lawyers, you often have two different views. So if the lawyer legitimately has a concern about the agreement, then he or she will say so. In mediation, the parties may reach an agreement in principle, and then when it comes to be reduced to writing, they may then disagree. So you can't guarantee that there'll be agreement all the way through. It's best to have counsel who knows family law, because then they can make sure that the parties are agreeing to what they intend to agree to, and that it's based on a reasonable approach toward the law, because judges are constrained. They have to deal with the law exactly the way it is, whereas a mediator can be creative. A judge, for example, can't divide property. In mediation, no problem, you can do that.
Right.
Not in arbitration, because again, you have to follow the law.
Right. So it's key to hire the right mediator, is that what you're saying?
It's really important.
I mean, kind of like what I said in the beginning is, no matter who you hire, it's, I always like when people go on social media, let's use Facebook for example, where people are always putting in search of a realtor, a lawyer, a mediator, a carpet installer, whatever have you. And if you look at their feed 20 minutes later, they have 100 names. Call this person, call that person. You're no better off than when you started, because whenever your 100 friends in this analogy post, call this lawyer, call this realtor, they don't say why. Why would I recommend this person? What are their credentials? Every lawyer knows the law. Every realtor knows how to put a sign on the lawn. But it's that specialized knowledge, the integrity, the genuine empathy, and all of those extra skills, some that can be learned and taught, and some that are just part of your human nature. So you also, I guess you would agree with me from what you said, don't just go out and hire any old mediator. If someone isn't in your area, and well, if you can't, call Howard, then make sure you do your homework and hire the right mediator.
Yes, you want to know that they have the requisite experience, and if possibly a certification as an expert family law mediator. That's really important. That would help. So there are ways to help yourself.
Okay, well, that's also critical. Great. So in closing, I wanted to talk about something with you that I'm not sure if we're going to have the same answer or not. We didn't rehearse this. I kind of like to wing it and see if I throw you a curveball, how you're going to answer this. I always like to talk about, with any new client or any other professional that I have the pleasure of working with or meeting, I always like to ask, what is the biggest mistake people make when they first decide to separate or first decide to split up with their soon-to-be ex? And I know what my answer is. I haven't asked you yet what your answer is, but why don't I throw my answer out there, and then let's see if yours is the same or different or how they compare.
Sure.
The biggest mistake that I've found with all of the people that I've worked with is, well, let's face it, unless you're independently wealthy and money's no concern, usually people are unsure. I mean, let's face it, everybody's unsure. Even if you're an accountant, you're still unsure right at the beginning of what your financial blueprint, your financial future is going to be. So the biggest mistake I've found that people make is they want free advice. And listen, if anybody wants to save money if they can, but you don't want to be a penny wise, pound foolish. So what they do is they hold on to every single dollar and they start asking their relatives, their friends, their bartender, their therapist, their realtor, anybody they can for all sorts of advice. And then in the end, they find out that if that advice wasn't accurate or didn't pertain to their unique situation, they realize it actually went a lot longer and a lot more stressful than it had to be, and ultimately ended up costing them more because they didn't invest in the right professional advice right from the beginning, which kind of like what you said about mediation is it's very important to hire the right professional right from the beginning. Even though you might have to pay for that advice, it might end up saving you thousands or tens of thousands of dollars in the long run. So that's what I've experienced. What's the biggest mistake that you see people make?
When you seek free advice, you tend to get what you pay for.
It's true.
So you're right. Penny wise, pound foolish is not the way to go. It's important to get the right advice, and it's important to get the right advice early, because if you make mistakes early on, sometimes they can be corrected, sometimes they can't. Invariably, I find when people represent themselves or take advice from their brother-in-law or sister-in-law, unless they happen to be a family law lawyer, they're going to leave money on the table.
I've seen that a lot. Yeah, and with all due respect, I've like I said, I mean, I've helped and worked with clients, and so I've met lots of lawyers and mediators, and some of them have different objectives than you might, and they've left money on the table. I've seen that time and time again. Again, it seems to be a recurring theme in this video is always go back to hiring the right professional right from the beginning. And in the long run, you're going to save time, which saves you money, and you can't put a price on your health and your emotional health and your physical health. That all comes from shortening the process, reducing the stress.
Well, just think about it. What you're dealing with in family law is your children, your income, and all of your assets.
Right.
Should be important enough for you to spend a few dollars and get the right advice.
Right, absolutely. Great. Well, if you guys have any other questions, by all means email them, and we'd love to have Howard back and always answer your questions on the program. And Howard, always a pleasure. Thank you for talking and helping everybody out, and I look forward to many more chats.
Great.
Thanks for watching.